Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about civil forfeiture. Cases that should have gone to the Supreme Court of Canada, but didn't. Mr. Liu was facing civil forfeiture proceedings in British Columbia Supreme Court, and in those proceedings, oftentimes what individuals do is say that the information that was obtained that supports the civil forfeiture application was obtained in violation of the Charter, whether it was unlawful searches, unlawful seizures, arbitrary detentions, or improper interrogations. And as a result of this, he brought an application to have the civil forfeiture proceedings or evidence obtained in the civil forfeiture proceedings excluded or discontinued as a result of violations of his charter rights. The Director of Civil Forfeiture sought to examine Mr. Liu in the processes that apply to civil forfeiture for the purposes of helping to make their case for civil forfeiture, given that he had challenged their action. They do have the right to do this. Mr. Liu wanted to bring his charter application first, and so he applied under the BC Supreme Court civil rules, asking that the matter be bifurcated, and that the charter application be heard before he was examined, before the merits of the litigation were heard. And this approach makes sense, because if the charter application is successful and the civil forfeiture proceeding loses the evidence or is discontinued as a result of the ruling on the charter breaches, no time needs to be spent, no taxpayer dollars need to be wasted examining him for discovery and advancing the other aspects of the civil forfeiture claim. Unfortunately, the judge did not grant this application. He sought an appeal to the BC Court of Appeal, which dismissed it, indicating that this was a discretionary decision of the judge that required a high degree of deference, and the Supreme Court of Canada denied leave to appeal. But this case does raise very important issues about one of the most important things that we have in our justice system: the use of judicial resources, and the use of taxpayer money in a smart way to conserve judicial resources and court time. It makes absolutely no sense to continue a proceeding that is more prolix and more lengthy as a result of the civil application and the charter applications being heard together. It makes no sense to subject somebody to an interview or an examination for discovery on the basis of information that may ultimately be inadmissible as a result of charter rulings. And so it is the best way to conserve judicial resources. And the Supreme Court of Canada has been interested in cases that talk about the proper functioning of our justice system. So it's a surprise to me that this case didn't get leave to the Supreme Court of Canada, because this case really gave the Supreme Court the opportunity to really show how we can protect these precious resources that we have. The ultimate consequence of doing things in a more lengthy, more complicated way is that it increases delay not only to that proceeding, but to every proceeding that then must be put on hold while this one takes place. If the Supreme Court of Canada had seen the implications for the long-term administration of justice in this case, they may have granted leave, but unfortunately it's going to take another situation where an application to bifurcate the proceedings and to sever the charter breaches and have them heard first is heard and denied before this is going to make its way to the Supreme Court of Canada. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Pool Creative for putting together these videos. Please like, subscribe, and share with your friends.